In this video, we're going to talk a little bit about where partnership law comes from and the law of forming a partnership. Agency law, which we studied before, is a creature of the common law. And to understand that, we focused on the restatements. Partnership law, what we're going to look at now, is statutory. Each state has enacted legislation that governs partnerships, and these come from the National Conference of Commissioners on Uniform State Laws. It's promulgated a number of uniform statutes in the business association area that have been adopted, some to a much greater extent than others. We'll look at a few of their statutes throughout this chapter on unincorporated associations. The subtle hint is always going to be that they start with uniform or revised uniform. The three things we're going to think about with partnership are the three Uniform Acts, the Uniform Partnership Act and the Revised Uniform Partnership Act, sometimes called RUPA, govern the general partnership form of business. These are the two most widely adopted. The 2013 revision of RUPA is still relatively new and has few adoptions. Don't forget what these are. These aren't exactly the law of anywhere. They're just model statutes. They only become the law once a particular state legislature formally adopts the statute as the law of its state. Typically, a state will change the name of the statute slightly to reflect that it's the law of that jurisdiction. So you might see the Rhode Island Uniform Partnership Act. Instead of saying too much about the legal attributes of partnership by way of introduction, I think it's best for us to just jump into the material. And what we're going to do is basically have a walking tour of the various features of partnership. Let's start with formation. So this is section 2.02a of RUPA, the association of two or more persons to carry on as co-owners a business for profit forms a partnership, whether or not the persons intend to form a partnership. Forming a partnership, like forming an agency relationship, requires no filing with the state. As long as you meet the statutory definition, you've created a general partnership, even if you don't realize it. In that sense, this is just like agency. What are we looking for in this definition? We need two or more parties who have agreed. The association, that word implies some consensual arrangement, to share profits and control. That's what we're looking for when people talk about co-owners. What does that mean? Well, profits and control of a business. What we're looking for, in other words, are people engaged in a business and sharing profits and control. The Revised Act says that someone who receives a share of profits is presumed to be a partner, unless it's payment for a debt or some such. But receiving a share of profits, while it is prima facie evidence of being a partner, it's not the only way to become a partner, nor the only type of proof one might look for. Becoming a partner can be a real risk for creditors. All the default rules we'll talk about would apply, including the rule that partners have unlimited liability for the obligations of the partnership. This is similar to the risk we saw in the Cargill case when we talked about agency. There, the risk was risks for a lender created by the agency relationship. We'll see when we talk about Volan versus Sweet how, again, a partnership can be formed without the partners necessarily intending